Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Now we are dealing with a case relating to the discharge petition. You are now well aware that discharge can be done under section 239 CRPC. But when discharge should be done is an important point. If there are if it is a groundless case, yes, definitely it can go for discharge by magistrate. Right? That is the important point. While deciding the case of State versus R soundirarasu. Right? State means DSP, Anti-Corruption Bureau. Right? Soundirarasu in criminal appeal number 1452 by 2022 on 5/9/2022, that is yesterday. So, two judges bench, Justice Dinesh Maheshwari and J.B. Pardhiwala. So, they clearly stated that court has to look into the prima facie aspects of the case, whether there are grounds to continue the trial or no grounds. That's all. Because prima facie 239, when it will come, so you may be knowing in chapter 19 of the CRPC, section 238 and 239, when accused shall be discharged, if upon considering the police report and the documents supplied under section 173, then the accused as the magistrate so and so, the magistrate consider the charge sheet to be groundless. This is important. If it is groundless, definitely it can be discharged. So normally it will not be done. Only in rare cases it will be done. Now we'll come to the factual matrix of the case. Right. The respondents, Mr. R. Soundirarasu and his wife, both of them are figuring as accused in a corruption case. That is a case registered under section 12 of the Prevention of Corruption Act 1988 against the respondents Soundirarasu and his wife. Soundirarasu was working as a brake inspector or motor vehicle inspector at Namakkal during year 2002. He worked as MEI in Namakkal from 1/1/2002 TO to 31/3/2004. Right? His wife is she is a partner in SK Mat Industries, which is a money lending company. She is doing money lending business. Of course, she is submitting the income tax statements right from 2003 itself. Of course, there are certain information. The ACB SUS, that is DSP, Vigilance and Anti-Corruption Bureau in Tamil Nadu, they conducted an inquiry against his assets and ultimately came to the conclusion that means the preliminary inquiry disclosed that he has amassed disproportionate assets because he rose from the rank of an ordinary man, but of course he has amassed wealth worth about 14.66 lakhs against his known sources of income. Right? So actually the raid was conducted. Ultimately the preliminary investigation was done. They are satisfied, and the ACB sleuths, they filed the charge sheet against he and his wife, taking her as an avatar. Of course, on 16/10/2007, the investigating officer, that is the ESP, asked for the explanation as to how he accumulated so much of wealth. Then R1, that is MEA, yes, he offered his explanation on 1/11/2007, and actually he filed the tax returns of his wife. But please remember, the IO did not take them into consideration. Why? Because it is a money lending business which is opposite to law in his view. Right? So as per the matter is undergoing trial in SC number 36/2008 before the special judge Salem. Right? At this particular point of time, this MEA and his wife, they filed a discharge petition under section 239 CRPC before the regular judge, that is a PDJ, but it was dismissed. Later, they went to the High Court of Madras. So Madras High Court also stated that prima facie his wife is a money lender. So we cannot discharge the case. There is enough material and he has to explain for the so-called disproportionate assets. So it's not allowed. Ultimately, the matter came to the In the High Court, they have allowed the discharge petitions, stating that the IO could have taken into consideration about the business. After all, money lending business is also a business. It's a finance business related to, it's not against to law. This is what is observed by the Honorable High Court of Madras. IO wrongly declined to consider the explanation of the wife of the MEI. So please remember. Now it is for the Supreme Court to decide whether the High Court has committed any error in this particular time. So please remember, as per section 13 of the Prevention of Corruption Act, please remember whether he has exhibited misconduct. So by using the public servant position, it is to be discussed at length. So how she as a, so is it sufficient that since she amassed wealth, it can be converted into name? Of course, in Indian law, both the wife and husband are one and the same. It's not like that. There is enough material because the ACB schools have collected so much of information. Therefore, the trial should go on. Merely basing on the information or the income tax returns of the wife, you cannot go for discharge. So, if there are any allegations which are groundless, definitely you can go for discharge, but in such cases you should not go. So ultimately the petitions were not allowed, the trial should go on. Ultimately they have to face the trial. So very good case law against to the MEA or the public servants. Please read the judgment and enrich your legal knowledge. Thank you very much.